Next.
Madam Chair, was there a determination that the moving party is not here in the building?
We do have someone who is going to speak on behalf of the gentleman who filed the paperwork.
Is it an attorney or is it the?
I don't know
The
that.
campaign manager.
Okay.
I mean,
I can address that if that person is here.
Is it Mr. Masterson?
Yes.
And there may be people here on behalf of the candidate as well who they can come forward as well if they wish.
Madam Chair, if we can have counsel address the matter of objecting party not being here, that's a potential issue.
Okay.
From my standpoint.
I don't know, I don't even know exactly who is here at this point, but I know the council is here from Washington as well as locally. And we have a candidate manager for the person who filed was not the candidate himself, it was someone else on their behalf. Is that correct? That's my understanding.
It's not clear to me who the person that filed is, frankly.
The Nicholas.
I know the name, but I'm not sure, I'm not sure what his
It's-
capacity is.
Got it.
So we do have a statute, 17-14-11, that deals with standing with respect to challenges to the authenticity, verification of signatures at the local level. When you look at the statute that deals with review, as is today by the board, there is no reference to the standing. It has been my view in the past that since the Gelch decision back in the mid-1980s, when there was a challenge to whether or not Mr. Cianci was eligible to be on a ballot for the city of Providence after being convicted of a felony, the person who made the challenge was not a candidate, nor was they were also not a party chair, very similar to the language of 17-14-11, which requires either of those two for standing. And it was just a resident of the city of Providence, and the Cianci campaign argued that because they could not set forth a particularized injury or were not a candidate, they nonetheless, the court found that they still had standing because it was a matter of significant public concern. For that reason, I would have recommended to the board that the person who did file would have been able to be heard. And that person is clearly not here. I don't know what your connection is to the person who filed. I understand you're a campaign manager for a candidate, but the person who filed, what is your connection with that person? Are you an agent, attorney, or someone else representing him?
So Nick Marletti, he's the campaign manager for Don Carlson. He submitted the challenge, and he is in Boston with his sick father. So I am the campaign director for Don Carlson. And I was here to get a statement from Nick on record. So I have a statement that I can provide to all of you to get on record for this hearing, and I'm happy to read it out loud as well on his behalf. I can also get Nick on Zoom right now.
I think in addition to what Mr. Eastmont has asked, we may also want to just hear from the Matos campaign. They may have a position they want to share. I don't know if they do or not.
Yeah.
Okay,
They should identify themselves,
Yeah.
please, and speak.
so let's just hear what they have to say and we'll go from there.
Good afternoon. My name is Michael Goldberg. I represent the Matos campaign.
And John Burkhan from the Elias Law Group also represents the Matos campaign.
Okay, so we do have, I think given the way that this has proceeded, I'm not sure, John, if you have any license in Rhode Island. I understand obviously you have license in a number of states. Are you also licensed here?
I am not, so I'm associating with Mr. Goldberg.
Okay.
I'll move to accept him as a valid counsel, given the fact that he's here with the Rhode Island counsel.
Yeah, I think all we can do, we can't admit someone to be licensed, but what we can do is allow this to proceed with motion before the appropriate court. So why don't
And we have commenced that process in
Then
terms
that's
of
all.
at least
Thank
drafting
you.
the paperwork and recognizing just the.
Yeah, you can proceed now.
Do you want us to address the first
Standing,
question?
I think we should address the standing and representation issue first before we get into the merits.
The other question I would have, Ray, is given the action that we took at the start of the meeting, what effect does that have, if any, on this objection?
Well, we can't obviously disclose much more than what we've already said by way of the vote, but it does seem to me that there could be challenges that are separate and apart from anything else that has occurred that would allow us to nonetheless hear the basis or the merits of the challenge to it, whether it's for signatures or residences or anything else, but we're not at that point yet.
So the first thing they're going to address is the standing issue,
Yes.
and then give the other gentleman an opportunity to address any specifics if we find that he has standing.
If we find that the gentleman here who has the report he wants to read into the record, we could proceed then, but we should at least hear from you as far as what your view is on the standing.
Yeah, so our reading, we agree, Counselor, it's not directly addressed in the statute, but in terms of the general structure, there's a clear requirement that an objection be set forth. And I think even if you assume, for purposes of this discussion, that standing is not limited to the candidate or party, the person who is filing the objection must be the person who brings forth and essentially prosecutes the objection at this hearing. And I'm sorry, I didn't catch this gentleman's name, but he's not the counselor for the objector. There's no direct relationship. He's not an agent of the objector. And I'm not aware of any precedent here that you would have someone who is not a lawyer or otherwise agent of the objector standing in for that person. So it's always, I think, would be our view that he's not able to proceed and represent the objector at this hearing.
Any questions?
Well, I would just ask for our counsel whether you concur.
To weigh in?
So based upon what I've heard, both from the gentleman who wishes to be heard on behalf of the objector, as well as the comments made by Mr. Burkhan, it is my opinion that the person here does not have standing to proceed with this. It sounds like there was, unfortunately, a medical situation, but it is also apparent that there was enough time to make sure that this gentleman was here, and perhaps if that was done, they could also have had an attorney appear, which would have remedied that. But there is no one who is authorized to represent anyone else unless you are a party, and we are a quasi-judicial board, so I always do look for attorneys to be involved. So it is my opinion that the complaint or objection, so-called, should be dismissed for lack of anyone here to submit argument or evidence on behalf of the person who made the filing.
I also think that the objection is not in proper format because it's not signed, it's not notarized.
Well, there would have been other reasons, and I think that there may have been more than one that we're considering, but one clearly was not filed in time and was not signed.
So I would, based upon what counsel has said, I would move to dismiss, but obviously without prejudice to any investigation that the Attorney General would have in the future. But with regard to this specific objection or complaint, if you will, I would move to dismiss based upon what both counsel and what Commissioner Scholes have rendered.
Second that motion.
We have a motion and a second. Do we have any discussion? Any questions? Hearing none? Yes, Mr. Giaconi?
Sorry, just real quick, to our attorney, tell me what exactly the statute again that applies here? Just the number, so I want to look it up.
For the statute on representation, well, that's a Supreme Court requirement that
Okay, sorry.
you cannot appear on behalf of another in a judicial proceeding and agency without being properly licensed as an attorney. You can, if it is your own interest, just like you can in court, appear pro se. But that's not a statute. There may be a statute that touches on it, but that's not what I was referring to.
Thank you, that answers my question.
So I have a written statement authorized by the objector, and that's all I want to submit to be on record.
Okay. Well, we have a motion and a second, and we should act on that motion and second, correct, Greg?
Well, once that's heard, then you could not introduce further evidence. I don't, is it in the form of evidence?
It's in the form of a written statement authorized by the objector.
Yeah, I think
And
unfortunately,
if I need an
That's what
attorney,
it's like
I have an attorney in the parking lot that I think would represent me.
We should have thought ahead.
I don't know why you would hold that in your vest pocket,
Yes,
sir.
right.
Yeah, well, I didn't know that I was going to need an attorney to submit a written statement by the authorized objector.
There has been a written statement
received
submitted already
something,
by
yes.
the objector.
Okay, great.
We have a motion and a second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed? It's a unanimous vote of the board. Thank you.
Thank you.
Thank you.